Whenever I hear an introduction like that, I think to myself, did I do all that? It's all a bit confusing. Just a little bit of background to where we are. I became interested in sort of information when I was asked to teach a course in law and information technology at Auckland Law School back in 2000. And that sort of grew into something a lot bigger. I became interested in information flows, in media, and the impact of new media on all sorts of things, the way we react, and some of the consequences of new media. But what has been most important is the way in which information can be controlled in the digital paradigm. But this is not new. And in fact, authorities, and I mean the state or organisations, have, ever since we've had recorded history, have tried to control information in some way or another. And every time there is a new technology that allows information to spread, there is some movement on the part of authorities or organisations to control the flow of information. And so there is always a challenge to that information flow or to the freedom of expression. Now, I use the term freedom of expression because that's the way that it's stated in the Bill of Rights Act, Section 14. Freedom of expression isn't just freedom of speech, which is the outward flow of information. It also encompasses the inward flow of information. It's not only the freedom to say something, but it's also the freedom to hear something. So that's something that's rather important when we're talking about freedom of expression. It's not just freedom of speech. Although in the First Amendment to the United States Constitution it's expressed in that way, but we've moved a little further on from that. So, when we're looking at the way in which organisations control the flow of information, we start with what we call the manuscript culture. Manuscript culture ran up to the development of the printing press in 1450. Everything was written down. But there was still control on the flow of information. The church was particularly interested in that, as was the state. And there were occasions when the interests of the church and the interests of the state came together. And one example of that was in the reign of Richard II and Henry IV in England. There was a group of religious radicals that were known as the Lollards, led by John Wycliffe during the reign of Richard II. And the Lollards had a slightly different view of the way that religious doctrine should be propagated. One of the things that they wanted was an English Bible, and that was quite revolutionary because it meant that everybody would be able to read, or those who could read, would be able to read in their native language, rather than in Latin, which was how the Bible was written. So control of the information would be taken out of the hands of the priests and was able to be disseminated to ordinary people. So the Lollards were quite keen on that. There was a tremendous pushback against Wycliffe, and Henry IV was one of those who led that charge. And they enacted a statute, or the Parliament enacted a statute called De Heretico Comburendo, which means concerning the burning of heretics, where Lollards would be taken from the hands of the church, given into the hands of the state, and executed by burning at the stake. So you can see that in that particular example is that coexistence, if you like, on the church's desire to control information and on the state's desire to control information. 1407 was the Constitutions of Oxford. We're still in the reign of Henry IV. Constitutions of Oxford said, if we're going to have any texts that are written about a religious subject, They've got to be approved by the bishops, and copies are to be kept in a chest at Oxford University. Now, we didn't have multiple copies as we do when they've been printed. It was rather limited, but that was one way in which the church was controlling information. Into the printing press, 1450, Gutenberg, first thing that he publishes is the Bible, believe it or not. But the printing press revolution that took place during the 15th century and into the 16th century brought all sorts of other interesting factors as far as information control was concerned, because the press had a whole lot of characteristics that manuscripts didn't have. First thing is that you had multiple copies. It wasn't just one copy handwritten out, but in an afternoon, 500 copies could be printed. That meant that information could be disseminated very, very widely and very, very freely. It also meant that the information that a person read in London was exactly the same as the information that could be read in York. So there was standardization of information. This was very important as far as lawyers were concerned. And one of the things that was recognized by the authorities was that the source of this disastrous spread of information was with the stationers, or who were the printers at the time. So there were efforts by the state over the 1500s and into the 1600s to control the development of the printing press and the use of the printing press. And it got to the point where state censorship started to take over. Henry VIII, for example, 1536, enacted a statute relating to the spread of information by print. And that state censorship continued either more strongly or less strongly through various reigns of various sovereigns. And what happened was that the law started to develop in such a way that it was specifically directed towards printed material. So you had laws about treason, laws about sedition that were being used to control the flow of information and to control those who disseminated information. One of the controls that existed was what was called licensing. From the time of Charles II through until 1696. Everything that was printed was licensed. You had to have a license. You couldn't have anything printed without a license. But Parliament failed to renew the statute in 1696 that allowed for licensing to continue, and from that time on, it was open slather. Nobody was subject to any sort of control. Daniel Defoe was one of the great pamphlet writers of the time and rejoiced in this fact on one hand, but didn't rejoice in the fact that when he printed stuff, other printers were able to print it as well. And he referred to them as pirates, these pirate printers. And we still use that term when people breach copyright. It's piracy. And in 1710, a new form of control over information dissemination came into force with the Statute of Anne 1710, which set up the copyright regime. So that can give you an example, if you like, a very brief canter over a complex subject of the way in which information flows were controlled. Now we are in another revolution. As much of a revolution, in my view, and it's been going on for a while, as the printing press was in 1450, and that's the internet. Because its impact is comparable. The only thing is that those qualities that the printing press had, like dissemination, standardization, and so on and so forth, are magnified. So instead of being able to disseminate a number of copies that the printing press could turn out, you can disseminate one copy and it goes to thousands, millions, billions of people, depending upon the platform that you're using. This all started in 1969. The United States government, or the Department of Defense, wanted to develop a communications network that would withstand a nuclear war. And ARPANET, as it was called, began to develop. It was within the context of universities that a lot of the hard engineering work was done, and making it possible for the information to flow was as a result of a number of innovations like packet switching, or what is called TCP/IP, which is the way in which packets of information are broken up, spread across various different ways along the internet and get to a destination, and the domain name system, which is the addressing system for the internet, because without a domain name, you don't have an address. And then in 1990, Tim Berners-Lee introduces the World Wide Web. And that made the internet accessible to the public, because without the World Wide Web, you really had to be somebody who was intimately involved with computers to know how to get the information. And it was complicated. So the internet brings a completely different complexion to the spread of information. And what has happened since the World Wide Web and Berners-Lee has been the development of a commercial internet. And we also have other developments that have taken place using the same sort of framework, such as broadband and wireless and smartphones, which allow for information spread, information communication. And now we're in a situation where we would be in some difficulty without the internet in doing certain business. And certainly, for example, the checks are no longer used by banks, for example. I put that down to the digital paradigm. Because what has happened is that people are making their payments using a smartphone or a card or internet banking or something of that nature. And the fact of the matter is that it is almost ubiquitous in terms of where we are going and what the future holds. And we have further developments that have been taking place, such as 5G and the Internet of Things and blockchain and, of course, artificial intelligence. But it's a communication system. When you boil it all down, the internet is no more and no less than a communication system. And it is subject to control. Now, you may think that that's a bit of an extreme statement, but look at it this way. We talked about Section 14 of the New Zealand Bill of Rights Act a few moments ago, and that guarantees freedom of expression. During the COVID crisis, our Prime Minister at the time, bless her little socks, said that the government is the sole source of truth. Excuse me, what's that but a restriction on information? Don't believe anything that you hear from other people with a grain of salt, were her words. We're the sole source of truth. So you have a state on one hand saying we're the sole source of truth, running up against freedom of expression on the other. Trouble was that anybody who disagreed with the government as the sole source of truth was contrarian, conspiracy theorist, anti-vaxxer, whatever. The problem that we have, particularly in New Zealand, is that that wonderful statement in Section 14 that guarantees the freedom of expression is not absolute, because it's subject to another nasty little section in the Bill of Rights Act itself, Section 5, which says that we can restrain freedom of expression if it's necessary within a free and democratic society. Section 5. Well, Section 5, in essence, introduces a relativistic approach to the freedom of expression. It is not absolute. It restricts freedom of expression and says that you can have freedom of expression, your freedom of expression will be restricted as much as is necessary in a free and democratic society. Now, what does that mean? You ask a lawyer, you get a lawyer's answer. It depends.
Kitchen.
Yeah, well, ka-ching. Really? You could swipe your card here. So, not only do we have the problem with Section 14 and Section 5 of the New Zealand Bill of Rights Act, but we also have other constraints on freedom of expression. You don't like what you heard on television? Oh, make a complaint to the Broadcasting Standards Authority. Because if your broadcaster is not complying with the codes that have been set by who? The Broadcasting Standards Authority. Then the Broadcasting Standards Authority can say that you've done the wrong thing and they can force you to make an apology and do all sorts of things. The New Zealand Media Council deals with other aspects of public dissemination of information via the news media. Broadcasting Standards deals only with broadcast, so you're talking about radio and television. New Zealand Media Council has voluntary membership, it isn't compulsory, and it too has a complaint system, and it too has 12 principles that it applies, and it entertains complaints. And likewise, the Advertising Standards Authority regulates truth and socially responsible advertising, again using a standard system. So you can see that these are organisations that are interested in the control of the dissemination of information in one way or another. Now, fortunately, it's relatively benign right now because, firstly, it depends on a complaint being made. They can't make what we call a Broadcasting Standards Authority can't make an own motion review of a particular television broadcast or radio broadcast. There's got to be somebody who's complained. And they've got to go through a process. They've got to complain to the broadcaster, and if the broadcaster doesn't listen to them, then they can go on to the BSA. So it's relatively benign at the moment. But within those organisations lies a greater ability to control freedom of expression and the flow of information. And then if you really want to get heavy, there's censorship. And we've got the Films, Videos and Publications Classification Act of 1993. And what happens there is that the Classification Office reviews and vets material, often that has been referred to them, and bans objectionable material. Now, the classification or the categorization of objectionable material is very, very limited. Very limited indeed. But an example of the way in which the Censor's Office works is that it can do something of its own bat. It doesn't necessarily need a complaint. And an example, and it's an extreme example, is the live stream of the Christchurch Mosque massacre in 2019, which was seen by the chief censor at the time. And on his own motion, he banned it. Now, perfectly correct that he did so. It was horrible. But that is an example of what can happen. If the chief censor doesn't like it, as long as it falls within the parameters of the legislation, it can be banned. It's generally uncontroversial. Objectionable material, it really is objectionable. And I've had cases where people have brought in objectionable material into this country or have been in possession of objectionable material. You only have to look at a couple of examples of a digital file, and we're talking about thousands of images, to understand why it is that this stuff has been made objectionable. But there have been specific cases where there's been controversy, generally about books. And there was a case some years ago about a book for teenagers that was to be restricted. Then the restriction was removed, and then the chief censor took matters into his own hands and banned the book entirely. And the matter was referred back, and the original designation of that particular book was restored.
What was the nature of the subject matter?
Yes, please.
I can't remember the title of the book, and I wish I could. It had to do with a rite of passage for teenage youth and sexual aspects and so on and so forth. Now, what we have as a further constraint on the freedom of expression is what I call a rise of safetyism. And the use of the word safety or safe is expanding in these days. And the question that you always ask, or we want you to be safe.
Yeah.
Okay, fine. Safe from what? Tell me, where's the risk? That's what they're really talking about, is risk. But of course the thing is now that not only can you have physical harm from somebody who comes and punches you on the nose, but you can have emotional harm from somebody who says something that you don't like. Because words are violence in the minds of the new critical theorists. And one of the words that the critical theorists use is safety. Now, in the Harmful Digital Communications Act 2015, we have a classic example of the way in which the law has developed to deal with online safety and online harm. It is an offence to intentionally cause serious emotional distress online. And how do you do that? With words, with an electronic communication. Online, yeah.
What if we just removed online and just said in general?
Well, I'm just going to get to that.
Okay, great.
All right? Because what you've raised is what we call internet exceptionalism. You see, I could say something particularly ferocious to you face to face. I could cause you serious emotional distress by the words that I use in this room. And you could do nothing about it. Nothing. If I do it online, I'm caught by the Harmful Digital Communications Act. And that's why I say it is an example of internet exceptionalism. Because behaviour that is allowable, it mightn't be right, but allowable in the physical space or the kinetic space is not allowed in the digital space, in the online space.
But wouldn't that apply to like printing out 100 posters and putting them around town? The same?
Nope.
It doesn't?
Nope.
Okay.
If they're not advocating physical violence, not a problem.
Right.
You see, yeah, exactly. But that's what I say about the kinetic space. You're talking about something that's physical,
Right.
whereas online, those particular posters could get you into all sorts of trouble if they cause people serious emotional distress.
Is it because it's public humiliation?
I beg pardon?
Is it because it's public humiliation, like online? Everybody can see it?
No, it's serious emotional distress. It isn't a question of public humiliation, it's how I feel.
Yeah.
I'm the victim. You're saying things about me. You've created a deep fake image of me that is, causing me all sorts of upset, anxiety, loss of sleep. My hair's falling out.
Does anxiety come from public humiliation?
It could come from public humiliation, but it has to be felt. It has to be felt by me. Okay, it has to be felt by the victim.
I think that's, I think the point though is that we shouldn't be intentionally causing serious emotional distress to anyone. And
Sure.
much less online or in person.
The point I'm trying to make is that I can do it to your face, but I can't do it online.
Right, okay.
So that's the exceptionalist aspect of it, you see. And the problem that you have is that, and this is where the freedom of expression thing comes in, if I put up a post online that causes you serious emotional distress and say isn't true, you can apply to the court to have that removed, taken down, okay? So you can engage a censorship process through the provisions of the Harmful Digital Communications Act.
Maybe it's because it sticks, because it's there.
I'm taking it a little bit further.
Okay, good.
Okay. Now what has recently happened is that a journalist has written certain articles and posted them online about communist China. Another person, Chinese, who supports communist China has applied to the court to have those particular posts taken down, suggesting that they caused him an upset. Now, the unfortunate thing about it was that it came before a judge who must have been a little bit too busy on that particular day because he didn't think about it carefully enough and said, yes, take them down.
Is that in this country?
That was, yes. Now, that was what? Political censorship. Okay, now, the fact of the matter is it came back before another judge because the person who was required to take the material down, the journalist, went back to the court and said, I want you to review this. And the court had another look at it and said, look, you know, there's no proof of serious emotional distress here. There's no evidence of it. And furthermore, it's political speech. It's an attempt to use the Harmful Digital Communications Act to stifle political speech. So the thing that arises from all of this is that as a result of the provisions of the Harmful Digital Communications Act, online speech faces stricter rules than speech in the kinetic space. And that's a bit of a problem. And that's where the safety thing starts coming in. Now, a few years ago, there was a proposal by the Department of Internal Affairs to review the entire media landscape, the whole thing. There was a proposal, what was called Safer Online Services and Web Platforms. And basically what it was going to do was bring the Censor's Office, the Broadcasting Standards Authority, the New Zealand Media Council, all under the one umbrella. There were going to be separate codes of conduct for each. The platforms were going to be controlled. It was going to be a censorship regime. That was the effect of it. There would be powers that would be vested in a single regulator to control content, including on social media. And the comparisons have been drawn between that particular proposal and a thing in the UK called the Online Safety Act of 2023, which has very, very broad powers and enforcement by an organisation known as Ofcom. See, Ofcom can require the removal of illegal and harmful content, but it can also require the removal of legal content if it's harmful. Illegal content, sure, not a problem. Legal content, well, excuse me, but if it's harmful, can be removed. Service providers
Who
have got...
determines if it's harmful?
I beg your pardon?
Who determines if it's harmful?
Ofcom.
Ofcom.
Yeah. Service providers can be liable. Senior managers can face penalties. Individual penalties, not the company. Individuals can face penalties if they have breached their obligations. There's age verification that is provided for in the English proposal, the British proposal, for social media access. It's not a ban. It's not a ban, it's just a requirement that there's got to be an effective age verification process. Problem that you have with that is that it can be circumvented. And circumvention is very, very easy. Because with a virtual private network program, you can fool the receiving outfit, organisation, that you're somewhere other than where you are. I'll give you an example. I wanted to see a program on PBS television online in the United States. Go to PBS, Renaissance, Blood and Beauty, click it, sorry, not available in your jurisdiction. Okay, sure. Hideaway VPN, where are you? I'm in Los Angeles. PBS, yeah, sure, off you go. Not a problem. It's as simple as that. Now, if I was going to be dealing with an outfit like Hulu or something like that where I had to pay a fee, there would be some slightly different complications arising because there would be contract terms and so on. But because PBS is free to air, none of that applied. So I was able to watch the program using Hideaway Virtual Private Network. So that's just an example of circumvention. That was lawful circumvention, there's no problem. We're not talking about circumventing age restrictions and so on and so forth. That may raise a whole lot of different issues if and when it ever happens. So when we're talking about things like age verification, you have all sorts of issues about privacy. You have all sorts of issues about jurisdiction. How do you enforce an age verification program in this country when the provider is in the United States or in Australia or Britain or somewhere else? And furthermore, what happens, what exactly are we talking about with age verification? A lot of publicity these days has been about stopping the under 16s accessing social media. And we want age verification to ensure that only people over the age of 16 are accessing social media platforms. So that means that anybody who wants to access a social media platform, assuming this comes law, anybody who wants to access a social media platform has to go through an age verification process. At the age of nearly 80, if I want to join a social media platform, I'm a little bit old for that, I would have to go through an age verification process, provide details of my name, date of birth, some kind of proof, like a passport or a driver's license or a real me or something like that, that I am aged what I say I am before I get access. So it doesn't just apply to kids, it applies to everybody. And of course, all of that data gets collected, and there are privacy implications about that. The other thing, of course, is that if I belong to a social media platform and they bring in age verification, do I have to reapply to belong? Is it retrospective? Do I have to reapply to belong? Do I have to re-verify my age? We don't know. And of course, the thing is that all of this is driven by a whole lot of assumptions about social media harms, which really mean that this is a desire to control information through the mechanism of the state, where the state becomes the definer, if you like, of the extent of parental responsibility. And there are other threats. If you thought that it's just from the state, there are others as well. For example, you've got a cancel culture arising, which has been going for some time. Books are banned from libraries. There are restrictions on speakers at libraries. For example, the Free Speech Union has taken a number of cases involving people who've wanted to do a public speech at a library facility or some other form of public facility where there has been some objection to the content of what they want to speak about, and so they have been cancelled or banned. So you've got these social pressures, if you like, that are coming to play on the freedom of expression. And I would suggest to you that this is an example of incremental erosions of the freedom of expression. It's not just happening all at once. It isn't going to happen overnight. It's just taking it clod by clod by clod. The erosion is happening. Your freedom of expression is being washed away into a state ocean. So, as Jefferson said, the price of liberty is eternal vigilance. It certainly is the case for freedom of expression. And new means of communication, digital platforms, social media, whatever, give new areas where there's going to be some sort of control or some attempt to control the flow of information. Because information, it's all about flow. That's what the freedom of expression is all about. Outward, inward. And of course the thing is, you've got to recognise this. You've got to see that it's happening. Because if you want to protect open communication, you've got to understand where the threat is coming from. It's very, very easy, as far as the state is concerned, But the cancel culture and the social pressures and so on and so forth are far more subtle and far more concerning. So, that's really all that I want to say about that. Let's talk about it.
Yes, let's.